All right, let's start this recording. All right, everyone. Welcome to what you absolutely must know about estate planning. Let me just share my screen really quickly. I'm excited. I think this is the first time I'm doing a estate planning webinar for folks specifically with minor children or who are taking care of minor children. So I'm excited about that. So just a little bit about me. My name is Danielle Brown, and I'm the founder and attorney of the Brown Firm. I'm very passionate about estate planning, especially in my minority communities. I got into estate planning based on some circumstances that happened in my family and the lack of estate planning that we had. And I realized how much of an information gap there really was just out there in general, right? So I have a goal this year to help 100 families get their estate plan in place. And you know, the help will vary from, you know, getting healthcare proxies or power of attorneys in place to getting a full comprehensive plan, which I would recommend for everyone, obviously. I'm also on social media at the Brown Firm. You can find us on Instagram and Facebook. And if you wanted to connect with me on LinkedIn, you can find me under Danielle Brown. So as you all know, estate planning can be very overwhelming and just to undertake in general. And many of you are here today or listening today because you have minor children in your life that you want to make sure are taken care of. Minors where they're your children, their grandchildren, nieces or nephews, or other intended beneficiaries, right? They all require some special planning considerations. So we are here today to answer some questions, to discuss some commonly used documents, and explore how children can benefit from you actually having a comprehensive estate plan. So first, let's take a look at some common questions we receive about estate planning from people just like you. So what is an estate plan? So you've probably heard the term estate planning, but may be unsure of exactly what it means, right? So simply put, estate planning is a comprehensive plan that addresses how you and your stuff are to be managed. The plan covers what is to happen to you and your stuff if you are unable to manage your own affairs, right? So this is otherwise known as incapacitated. The plan also covers what's supposed to happen to you at your death. And what if you don't have an estate plan? So it's important to know that death is not the only parenting risk for which you need a plan. If you were to become incapacitated tomorrow as a result of a tragic accident or a life-threatening illness, what would happen to your children or your grandchildren or your minor dependents, right? Who would have access to assets that are needed to fund their care? If you become incapacitated and have not created an estate plan, well, your loved ones will have to go to surrogates court and ask to have someone appointed as your guardian to make financial and medical decisions on your behalf. And the judge may not appoint the person or people you would have wanted. And this process, which is called a guardianship proceeding, can be very costly. It can be time consuming, and it's a matter of public record. Also, when you die without an estate plan, state law determines which of your family members will receive your money and your property and how much they will receive. It's determined by statute or law, right? And may not be the outcome you would have chosen. And this process is called estate administration. And this can also be very costly, time consuming, and it's definitely a matter of public record. So estate administration is not to be confused with a guardianship proceeding, which I just spoke about, or probate, which we'll speak about soon, right? Estate administration is specifically for when you die without an estate plan in place. I want to note here that there are some accounts and assets such as life insurance or retirement accounts that can be passed on at your death without having to go through the estate administration if you filled out a beneficiary designation, right? So other properties such as real estate, business interests, tangible personal property like clothes, furniture, those things, or others will require the court's intervention in either an estate administration or a probate proceeding. And those things are subject to state laws. We'll also talk a little bit about beneficiary designations as they relate to minors just a little bit later on. So what is probate? When talking about estate planning, many people say that their objective is to avoid probate. However, before it can be avoided, it is best to understand exactly what probate is. Probate is the court process of determining three things. First, the probate court will determine whether the person who died, also called the decedent, had a valid will. This determines if the court will use the instructions the decedent laid out in the will or use state law, to determine who gets what. Next, the probate court will determine who's in charge of winding up the decedent's affairs. So who is appointed to the role depends on whether or not the decedent names someone in a will and if that person is willing to serve. So it's important to make sure if you are naming someone to wind up your affairs that you make sure that they're willing to serve in that role, right? And that person is called the executor. Lastly, the probate process determines who will receive the decedent's money and property. And this is done by looking at the instructions in the will. So while probate is an important process, there are several downsides. It can take a while to get through the whole probate process. Here in New York, on average, it takes anywhere from 1 to 2 years, right? It can be expensive between attorney fees, court costs, and other administrative expenses. And the whole probate proceeding, becomes a matter of public record. This means that anyone can access a copy of the will or any other documents that have to be sent into the court. So because of that delay and lack of privacy involved in probate, avoiding it is best when minors are involved. Another important thing to note is how estate assets will be transferred to a child in a probate or estate administration proceeding. Practically speaking, a child cannot inherit money or property until they're 18. If you leave money to your child outright, the child becomes entitled to the money and they become entitled to the money before they turn 18, then a guardian of the property will have to be appointed through the surrogate's court before your child can physically access the money. What's even worse than that is once the guardian of the property is appointed, the money must be jointly held by the guardian of the property and the court. And in order for the guardian of the account to withdraw money, they have to petition the court for permission to withdraw funds. And as you can imagine, this becomes unduly burdensome for that guardian. Additionally, once a child reaches the age of majority, which is 18 here in New York, all assets in the estate of the minor would be distributed directly to the child, regardless of that child's ability to manage the money. And, that's a problem for a lot of folks. So I know some of you, are clever, right? So you may be thinking, can I just add someone to my accounts and property as a joint owner so that when I die, that this person will automatically receive the account and the piece of property? Well, by adding a child, a sibling, or a friend to your account or piece of property, you're subjecting those accounts and property to your new co-owner's creditors, right? So this means that if they were to be sued and there was a judgment against your co-owner, your account or property may be taken to satisfy that judgment. Right. In addition, as a co-owner, they have all the rights of a co-owner. So in the instance of a bank account, that co-owner could drain your bank account without your permission because they're a co-owner and they have the right to do so. Lastly, depending on the value of the account or the property, right, you need to consider the gift tax consequences. So in 2022, you can gift an individual up to $16,000 without having to file anything with the IRS. However, if you exceed that amount in the calendar year, you'll have to file a gift tax return with the IRS. So that's something to keep in mind as well, is that when you put someone on as a joint owner, it's considered a gift and you may face tax consequences for that. So, people say, can I just complete a transfer on death or a payable on death or just add them as a beneficiary designation? Well, yes, some accounts allow you to name a beneficiary designation, a transfer on death or a payable on death beneficiary, so that when you die, that account will either be transferred or paid to that person without court involvement. While these beneficiary designations can be incredibly efficient, right, at transferring your account to the intended beneficiary upon your death without going through a probate or estate administration process, it can be very dangerous upon the nature, dependent upon the nature and value of the account. Any distribution of an account to a beneficiary makes it the sole property of the beneficiary. So once in the beneficiary's hands, it becomes vulnerable to any claims by creditors, judgments, or divorce proceedings even, right? And the beneficiary may not have that money for long. So if they have student loan debt and they're on a pay-as-you-go income plan or pay-as-you-earn or it's an income-based plan, them receiving this money outright can then change the amount of payment that they're supposed to make to student loan. If they have any lawsuits against them or any judgments against them, your inheritance can be used to satisfy those judgments, as we saw. If your beneficiary is married and potentially gets divorced, the ex-spouse may have access to that as well. Now, I want to emphasize here, and I think I said it earlier, do not designate your minor child as a beneficiary. If you designate your minor child as a beneficiary, and if something happens to you before the child reaches the age of 18, then, like I said, a guardian of the property will need to be appointed in order to collect that money, even if there's a beneficiary designation, right? So you can't circumvent it by adding them as a beneficiary designation. Children cannot own money or property. So I know I mentioned that earlier. I just wanted to add some extra emphasis because no matter how many times I say it, people tend to do that anyway and gets themselves in a little bit of trouble, or not really trouble, but in a situation that they wouldn't want. So you may be thinking, right, how to avoid probate if you're advised not to add a person as a co-owner or not to use beneficiary designations. Well, the key to avoiding probate is to make sure that when you die, that you don't have any account or property owned solely in your name. Right now, obviously, I'm not saying that you give away all your possessions, so you die owning nothing. In fact, there's a way that you can transfer your accounts and property out of your name while still retaining the benefits of it. And the way to do that is to establish a trust, right? So in this trust, you would name a trustee, someone who's going to follow the instructions laid out in the trust. And in the beginning, this can be you. You can also establish who will take over for you if you die or are otherwise unable to carry out your duties, right? Next, you will determine who you want your beneficiaries to be. While you're alive, you'll be the current beneficiary. And upon your death, you can choose anyone to be your beneficiary. And the trust will allow you to lay out specific instructions as to when and how the beneficiary will receive money. Lastly, the most important part, you need to you need to make sure that you retitle your accounts and your property out of your name and into the name of the trust, which adds them to the bucket that you see there in the middle. Accounts and property can include your home or other real estate. It can include your bank account. However, it should not include your retirement accounts or life insurance policies. You'll want to keep these in your own name because they have beneficiary designations. And for these accounts that you want to keep in your name, you want to name the trust as the beneficiary so that the trust will eventually own the account or receive the money outside of probate without changing ownership today, right? Because there are tax consequences that come along with changing ownership of retirement accounts, et cetera. So you want to make sure that you're naming the trust as a beneficiary designation. As I mentioned earlier, the key to avoiding probate is to ensure that you don't have any accounts or property owned solely by you upon your death. If your trust has been properly funded, you will die without any accounts or property in your name, but you will have received the benefits of those accounts and property during your life. So upon your death, the successor trustee will inventory all the accounts and property that make up the trust. Next, the successor trustee will distribute the money and property to the beneficiaries according to the instructions that you laid out in the trust. And all of this will occur without any court involvement, without a probate proceeding, without an administrative and estate administration. And this eliminates the risk of the minor beneficiaries' inheritance being discovered by an unscrupulous person or, a predator or a creditor or something like that. A revocable living trust can also eliminate unnecessary delays in the availability of funds to a minor beneficiary who may, more than any other beneficiary, need the funds immediately for his or her basic care and needs. So we talked about, how the trust works, right? And we talked about the trustee who you'll name to make sure that they follow the instructions in the trust. Naming a trustee to oversee a minor's inheritance is perhaps one of the most important decisions you'll make. The most logical choice for a trustee of a minor's trust may be the minor's other parent or guardian, right? However, a parent or guardian may be overwhelmed by the day-to-day responsibility of raising a minor child and may not have the time or the skill set needed to serve as a trustee. Naming another relative or trusted friend may be a good alternative, although a growing number of grantors are the people who actually create the trust, they're opting for professional fiduciaries, right? Professional trustees, corporate trustees. But I just want you to know, here are some guidelines for choosing a trustee. First, expertise is not required. A trustee is a fiduciary required to perform certain tasks bound by duties owed to the trust beneficiaries. However, the individual selected need not be a financial industry professional to be qualified to serve as a trustee. It's important to select a trustee with good judgment and common sense. For example, the trustee must be comfortable doing research and asking for help. That's as basic as it is, really, right? You also want to consider the trustee's age. Because a trust for a minor is likely to be administered for a significant length of time, right? Decades or even longer, because they're minors, so their lifespan is going to be a little bit longer. It's prudent to consider the age and health of a potential trustee. So you don't want to choose someone who's older, who's probably going to pass away prior to them, or who has significant health concerns, right? Another thing you may want to do is naming multiple successor trustees and revisit their appropriateness as early as every 3 years. Every year, you may want to look at these documents to see if your trustees are appropriate. These documents are not set it and forget it documents. And I want to make sure that everyone understands that you need to look at your estate planning documents to make sure they still reflect your wishes. It's not every year that you need a change, but you want to kind of check in to see that everything is still the same. Another thing you want to do when you're considering trustees is you want to consider the team approach. In some circumstances, naming more than one trustee may be appropriate. So some benefits of having co-trustees are the sharing of administrative duties and preventing one person's judgment from controlling all decisions and distributions. The role of the trustee can also be split by having one trustee who is responsible for distribution decisions, while having a second trustee be responsible for investment decisions, right? So you can split that role and kind of have a team approach to that. But sometimes a professional trustee is best. When a trust contains a large amount of money, or there are concerns about family conflicts or something like that, that's typically when a professional or institutional trustee may be best. And even in the most thought out plans, things can go awry. Rogue trustees happen, right? Changes in law happen, and other unforeseen circumstances can defeat a grantor's original intent. So, back in the day, there was a time when court intervention was the only course of action. However, asking a court to reform a trust or otherwise intervene to fix a problem is a time-consuming and expensive remedy. So today, the appointment of a trust protector can provide peace of mind to the grantor and ensure that the trust is viable over time, right? And what a trust protector is a neutral third party, unrelated to the grantor, unrelated to the trustee, and unrelated to the beneficiaries typically. Some common powers that are bestowed upon a trust protector are the ability to direct a trustee, to appoint a new trustee if one is unable to serve or has passed away. A trust protector can amend a trust. They can change the jurisdiction of a trust. So if your child is moved, they can, if there are other things like that, that trust protector can step in and kind of help to make sure that the grantor's wishes are being carried through. So when a trust is created for a young minor child or is intended to provide for descendants over several generations, a trust protector can aid in ensuring that that the grantor's intent is honored in spite of those legal changes. So I know there's a few folks on mute. If you have any questions, I want you to feel comfortable jumping off of mute, asking your questions, or you can put them in the chat. I'll be happy to answer those questions there as well. So, like I said, there are many simple ways to provide for minors, including outright gifts of money or property, naming a minor as a beneficiary of a retirement plan or life insurance, which I told you I wouldn't recommend, or would I recommend giving it to them outright, right? Or you can create a uniform transfer to a minor account called a UTMA account, typically. And while these things are simple, they're not always better. And these gifting strategies do not address a minor's potential immaturity or inability to handle an inheritance, nor do they protect an inheritance from an unforeseen circumstance or future creditor. These concerns call for a more thoughtful approach when planning for minor beneficiaries. And a carefully designed trust is a superior estate planning tool to prevent a minor child from squandering his or her inheritance and to protect the fund from unanticipated future creditors, right? So as I mentioned, a minor trust can name a trustee to manage, invest, and distribute the assets to the minor child according to the terms of the trust. A trust is a very flexible document. It can literally do whatever you want it to do. And the trust may also allow distribution for the child's health, education, maintenance, and support throughout his or her life, right? The trust can also terminate at a specified age of the child as opposed to at the age of majority. Alternatively, the trust may distribute principal and increments based on the age of the minor. For instance, the child would be entitled to demand 1/3 of the trust principal at age 25, right? You may say, I want them to be able to demand another 1/3 of it at age 30, and the final 1/3 of it at age 35. As I mentioned, the trustee need not to be a professional trustee. And in the event of a smaller estate, it may make better financial sense to name an individual as a trustee, and then that individual can go out and hire an investment advisor to handle the investment of the trust assets. So, we talked a little bit about some of the considerations, but one of the number one fears that I get from parents and guardians when they have minor children is they want to know who's going to take care of their, child if something happens to them, and their other legal guardian or parent. Not only must you consider what will happen at your death, but you also should consider what will happen during any periods of incapacity, or if you're geographically unable to make the necessary decisions, right? So you would want to make sure that you name a temporary guardian, right? And a temporary guardian is someone who will look after a minor child and make decisions for a short period of time, such as if you're traveling without the child or you become incapacitated. This person is usually named in a separate document other than a will. And on the other hand, a permanent guardian is appointed in a will. And this is the person that takes care of your minor child if you die and the other legal parent is unable to care for the child, right? If they're also deceased or if they're unfit in some way. So when deciding on a guardian, parents should take into account, parents or guardians or grandparents, right, should take into account the proximity of the guardian's residence to the children's current home. You should also take into account the lifestyle and religious beliefs of the guardian and the financial situation of the guardian, right? Because while someone may be able to, good to with kids, they may not financially be able to handle it. Parents should name the same guardian in their wills. If you're doing joint planning, you should name the same guardian in your will as to avoid any confusion in the event that you both were to pass away. Assuming guardianship of a minor is a major responsibility, right? And parents should be sure to ask their preferred guardian if they would be willing to care for the children in the event of a tragedy. So I know people often come and they want to name a guardian, and I say, hey, did you speak to this person? No, but I know she loves my children. Yeah, but you don't know if she loves your children enough to take care of them for the rest of their life. So that's something you'll want to confirm if you want to name that person as a guardian. So I talked a little bit about, a trust being the best way to go. In addition to making sure that you choose someone to have physical custody of your child in the event that you're incapacitated or pass away, it's also important to discuss what will happen to any money or property that the child may inherit, right? So we talked about that children can't control money while they're underage. So you want to keep this in mind and kind of figure out what exactly is going to happen with the assets that you want to pass on to them. So choosing a trust is just part of the solution when planning for minor beneficiaries. You including certain provisions in any trust can protect minors from creditors, predators, or the mistakes of youth, honestly. In fact, carefully drafted provisions within a trust itself provide the greatest opportunity to leave a thoughtful legacy for your minor beneficiaries, protecting beneficiaries from themselves and others. So here are some common provisions that you may want to include. There are incentive provisions, right? And grantors often worry that a minor beneficiary may become the quintessential trust fund kid, right? Using the trust to escape responsibility, growing up lacking proper self-motivation, or failing to become self-sufficient and provide for those dependent on them. Incentive provisions can be added to a trust to encourage the beneficiary to engage in positive behaviors, such as donating time and money to charitable causes, engaging in creative and cultural activities, showing empathy towards others, or maintaining healthy relationships, right? Incentive provisions can also require a beneficiary to obtain a certain level of education, to reach a particular age before receiving a distribution, to demonstrate the ability to handle money or to be gainfully employed. You can also incentivize beneficiaries to become property owners or entrepreneurs by giving them a distribution when they engage in behaviors that align with your wishes. For example, If you have a minor child that you would love to be a property owner, you can say they get a distribution for their down payment for their first home, or they get a distribution when and if they're going to start a business, or if they need a business loan, something to that effect, right? Another provision that you may want to include in a trust is a spendthrift provision. When a spendthrift provision is included in a trust, it provides a higher level of asset protection that would otherwise not exist, right? Grantors often worry a minor beneficiary may spend his or her inheritance away. I don't know about you, but I have some beneficiaries that, I'm not sure if I were to give them money today, if they will still have it by tomorrow, right? So either knowingly or by getting into debt or legal trouble, you want to prevent these people from dwindling the inheritance. So a spendthrift provision voids any attempt by a beneficiary to assign his or her interest in the trust to another, such as a creditor, and also prevent a creditor from reaching the trust principal. So put in other words, if your beneficiary were to have credit card debt or anything like that, and they say, well, I have a trust, I'll just give you the assets from the trust, and a spendthrift provision will prevent that from happening. Another provision that folks may want is a bad behavior clause, right? Another common concern among grantors is that the unfettered access to money will result in a minor beneficiary engaging in harmful activities or failing, or falling prey, to abuse or addiction. Exorbitant spending, abuse of drugs or alcohol, gambling, or involvement in criminal activities are among the issues that are so-called bad behaviors. And the bad behavior clauses are aimed to address or prevent those things. So similar to an incentive provision, which I was just talking about, which encourages and even rewards a beneficiary's behavior and choices, bad behavior clauses address a particular negative behavior a beneficiary may engage in, right? So a carefully drafted bad behavior clause can deter the beneficiary from participating in certain harmful behaviors, such as drug abuse or gambling, or by allowing a trustee to turn the trust fountain off for future trust distributions until the beneficiary rehabilitates himself or herself. So to promote and assist with the rehabilitation, the trustee may be permitted to use funds from the beneficiary's trust for the beneficiary's counseling or for treatment, or any other mental health services that may be needed. Once a beneficiary is sufficiently rehabilitated, then the trust distributions may be reinstated by the trustee. Another provision that many people may want to include is standby supplemental needs provisions, right? So if a beneficiary unexpectedly becomes disabled, incapacitated, or otherwise unable to care for himself or herself, the beneficiary may be unable to manage an inheritance or on his or her own. Even worse, the beneficiary may be disqualified from receiving much needed government aid and assistance because of the inheritance. Most common trusts are considered a countable asset when a disabled beneficiary applies for aid, so if they're applying for Medicaid, et cetera. And the beneficiary must then spend down the trust before receiving assistance. And this standby supplemental needs trust allows the trustee to convert an otherwise disqualifying trust to one that does not affect the beneficiary's eligibility, while still allowing those needs to be covered by the governmental program and giving them access to some additional funds that supplement those benefits. Another thing to consider is if you have a blended family. A lot of people don't realize that minor children can sometimes be unintentionally disinherited if there's no estate plan in place, right? So for example, if I have a son and then I go out and get married, and let's say I marry Bob and my son's name is Adam. Well, if I marry Bob and we have children together, let's say we have a daughter named Carol. When I marry Bob, if I pass away without an estate plan, well, the majority of my assets go to Bob. And if Bob similarly passes away without an estate plan, well, guess what? Now, Bob is his assets are going to pass to Carol, and then Adam is going to be disinherited. And it's by no ill intention by anyone. We just didn't have an estate plan in place, right? So we forgot to provide for Adam. So a lot of people don't realize that in blended families, you can sometimes disinherit a child unintentionally. Another thing that you want to keep in mind is you want to know how much you need to leave behind, right? You want to take the time to sit down and calculate how much it would cost to raise all of your children to the age of 18 or beyond. And although you may not have the assets available right now to fulfill that type of commitment, you can use life insurance as a cushion until you build up your asset portfolio to the point where you feel comfortable with what you're leaving behind, right? So for example, I know that you can sometimes get a policy, depending upon your age, you can get policies for, if you're in your 30s or so, you can get a policy for $1 million. That's like $60 a month, right? So those are things that you would want to consider, but you would want to sit down with and potentially a financial advisor to see how much money it would take to take care of your minor beneficiary until the age of 18. Again, if you have any questions, feel free to hop off of mute or jump into the chat, and I will be happy to answer those questions.
I have a question.
Yes.
I'm curious to know, what if the parent, the guardian you have in mind to take over after, say you pass on, what if they're out of country? Like, what does that look like? Mm-hmm.
So what it would look like is you should name a temporary guardian in place, right? And a temporary guardian will be someone who is much closer, and can get to the child and immediately. So you would name that person, and then you would name that out of country person as your permanent guardian, right? So while the temporary guardian is taking care of your minor child, they can put plans into place, or your executor can put plans into place to have the child move to the country where the permanent guardian will be.
Okay, thank you.
Absolutely. All right, so we talked about insurance. There are some other estate planning documents that you should also have when it comes to your estate plan, right? So we talked about the benefits of a trust and how to avoid probate, how to provide asset protection for beneficiaries. We talked about some supplemental needs stuff if a minor child is going to need governmental benefits, right? But there are also some other important documents. And one of those documents is called a power of attorney. And this is a document in which you can name a trusted individual to be your agent. And as your agent, this person is in charge of handling the financial or business transactions on your behalf, right? And this can include things such as signing a check for you, opening a bank account, or talking to a plan administrator. When your agents act and how much authority that agent has is something that can be customized according to your state law, right? And here in New York, we can make it as broad as we want to make it, and we can make it as narrow as we want to make it, right? We can say we want it to be a springing power of attorney, which means that power of attorney comes into effect when you're unable to manage your own assets, or if you're incapacitated for any reason. And we can even identify what incapacitation looks like, right? What constitutes incapacitation in the document. Or we can also make that power of attorney effective immediately, right? And it can be a document that goes into effect the moment that you sign it, and it can stay into effect until you pass away, or until you rescind it while you're of sound mind. So it's important to know that the only way to revoke this power of attorney is you have to be of sound mind to actually do that. Another document that you want to make sure that you have is a healthcare proxy. And a healthcare proxy allows you to select a person to make medical decisions for you if you cannot. So it's important to know, if you can make healthcare decisions on your own, this healthcare proxy will not be effective. All right. Without a healthcare proxy, your loved ones, as I mentioned earlier, will have to go to surrogates court to have a judge appoint someone. So, like I said, it's time consuming, it's expensive, and it's public. And you may end up with someone making medical decisions for you that you would have never picked, because the judge really doesn't know the dynamics of, your family or your loved ones, even if it's not family. And, you may have family and you want to appoint a friend to this position because they're a nurse or they have better knowledge or they're aligned with your religious beliefs. So these are all things that you want to keep in mind. Also, this can be a very emotional role. Not everyone is built to be in this position and to make these decisions. And these are often quick decisions that need to be made, right? So you want to know, can this person handle that level of responsibility and the stress that comes along with it? You also want to consider whether or not this person can get to you in a quick manner, right? You don't want to choose someone across the country who can't get to you and who can't answer the doctor's medical questions. So, it'll be impractical to kind of pick someone who's living across the country or something like that. So by planning ahead, you can choose the person that makes sense, not necessarily the person others would choose, right? For example, your loved ones may live in a different state. And like I said, like your best friend is a nurse who lives next door, and she'll be the perfect person. But by planning ahead, you can kind of make these decisions ahead of time. Another document that you'll want to keep in mind is a living will. In some other states, they combine this with the healthcare proxy and they call it an advanced healthcare directive. And what a living will does is it gives you the opportunity to communicate with your loved ones exactly what your wishes are regarding your end of life care, right? So this can be extremely helpful if you're unable to communicate your wishes, instead of leaving your loved ones to figure out what you want and argue about decisions. You can give them the peace of mind by letting them know exactly what you want. I can tell you, I dealt with a case like this just this week, and where someone was on life support and the family members were arguing. They didn't know whether or not to keep them on life support or not. So this is something you can assist your family members with by letting them know how you want to be taken care of and if you're ever in a terminal condition. I want you to know that this is not a do not resuscitate order. It is not the same thing. A do not resuscitate order that's typically prepared at a hospital. A living will just speaks to end of life care regarding artificial nutrition and hydration. Do you want your life to be prolonged if there's no chance of recovery? All right, so some of you may be thinking, oh, this sounds good. What do I do next? Well, what I would recommend for you is to schedule a consultation, either with my firm or with an experienced firm who does estate planning. It's important to choose people who actually practice in this area. So there's a lot of people who will say that they draft wills. Drafting a will and being an experienced estate planning attorney is not quite the same. You wouldn't go to a dentist for a foot problem, right? So you want to keep that in mind. But you can email me if you have questions, right? Let me drop the link in the chat for those who may want to schedule a consultation. But you can email me at Danielle at the Brown Firm. You can go to our website and kind of check out more information. We have a ton of blogs on estate planning and how you can get started. We have additional information. And we do webinars monthly. They'll be on different topics regarding estate planning, but that's it. So do we have any additional questions or anything that I can answer for anyone who's joined us?
I don't have any questions, but I want to say thank you. I've learned so much from this seminar.
Awesome. That makes me happy. Thank you, Whitney. Yes, so this recording will actually be going out tomorrow. You should receive it in your inbox. We'll send an email out with the recording as soon as it's ready, actually. All right. Awesome. So if there are no more questions, I'll go ahead and log off. I want to thank you all for joining. I would love to hear your feedback. So feel free to leave me an email or send me an email. Sound like send me an email or follow us on social media, and we'll be providing more tips. Have a great day.